Well, it's our great pleasure today as we have another one of 4SA's podcasts on things which we believe are really interesting and significant to the faith communities of South Africa, to be joined by Advocate Paul Hoffman. Paul is a very, very experienced senior counsel. He was some 26 years fighting various cases and litigating at the Cape Bar, and he is currently a director of Accountability Now. He's been in the NGO sector, particularly since 2006. And today we're going to be having a discussion on the centrality of the rule of law to the proper enjoyment of religious freedom in South Africa and obviously beyond. So it's going to be hopefully a very wide-ranging but very topical conversation. And Paul, welcome. And thank you so much for joining us this afternoon.
Thank you for the opportunity, Michael. I'm all set to go.
Wonderful, fantastic. Well, Daniela has been obviously very interested in this subject, and we heard you talk about it, and we've just had a conference on it that we had in Stellenbosch a couple of weeks ago, and this was very much a central topic there. So we wanted to get your input and your expertise, and Daniela has, I think, got a lot of questions that she'd like to ask you.
I do have a lot of questions. So I'm Daniela Ellebeck. I'm 4SA's legal advisor, and Paul, it's an absolute pleasure to have someone of your caliber on our show. Thank you very much for being willing to be interviewed by us. So my first question is, what is the rule of law in South African law, and where does this idea of rule of law come from? Like, what does it mean? Where does it come from? What does it entail?
So let's try and work out what the rule of law is to get to your very first question. And I must say that it is a concept that defies definition. You look at it historically, it is the idea that the king can do no wrong, that the sovereign knows everything, and that the people must bow before the sovereign, which was obviously a rule by a man or woman who was the sovereign at any given time, to the idea that the law is supreme. So the supremacy of the rule of law means that the tenets of the rule of law are the guide for governance and are enforceable through the courts of the land or such other adjudication processes as are available. Now let's have a crack at a working definition of the rule of law, and I'm going to rely on it to the four universal principles that have been identified by the World Justice Project. If you're not familiar with the World Justice Project, if you go to Google and just put the words World Justice Project into the search engine, you will find yourself on a most interesting website where a group of people worldwide, but based in Washington, seek to prepare each year an index of the rule of law in the countries which they study. And South Africa features on that because we're an interesting country, having done the peaceful transition from parliamentary democracy or parliamentary sovereignty to a constitutional setup in which the Constitution is regarded as supreme, and any conduct or law that is inconsistent with the Constitution gets struck down as invalid. So their four universal principles, if you want it in four words, would be accountability, certainty, transparency, and enforceability.
So Paul, given that you've really set out a very clear, I think simple to understand definition, and everything sounds good and reasonable, how are we doing in terms of our Constitution? How is the application of the rule of law on a practical level being respected and implemented in how we are functioning in this society?
Well, I'm glad you held up the Constitution to me, because what I can hold up to you is the rule of law index in the form of a spider graph. Now, perhaps I should explain what the spider graph is before I introduce the audience to the picture, because otherwise you may be scared by the spider. What they have done is, by way of empirical research, polling of the general population and questionnaires for experts in the law are circulated in all of the countries that have a rule of law index score. And the questions that are asked in the questionnaires for the public and for the experts really revolve around 8 factors. There used to be 9. Informal justice was a 9th factor, but now it's been reduced in the 2022 index, which is the one that you will see if you go onto the World Justice Project website. You will see that 8 factors are set out. So those 8 factors are constraints on governmental power, absence of corruption, that's the second one, which is a big one for us. Factor 3 is open government. In other words, do things happen in smoke-filled back rooms, or do you have openness and transparency in your government? Fundamental rights will depend on whether or not there's a justiciable Bill of Rights, and I'll come back to that when we drill down a bit into religious rights. The 5th factor is order and security. In other words, are the police and the army doing their jobs? Regulatory enforcement is important. If you think of the train crash in Greece the other day, that was because they had a single track where they shouldn't have had a single track. Then there is civil justice, which means when there are disputes, are they dealt with in courts in a civilized fashion? Criminal justice is obviously where the prosecuting authority gets to enforce the criminal law. And then the 9th one, which has fallen off the map lately, is informal justice. They don't keep that as a separate heading anymore. So let's get down then to the South African picture, and this is how we look on the spider graph. I don't know if you can see that.
Maybe hold it up a bit more, but I'll also make sure to drop a screenshot of that into this talk for people.
Yeah, perhaps if you put a screenshot of the 2022 one. Now, the dark line on that graph is the one that shows South Africa's, and the others are in relation to our geographical area, sub-Saharan Africa, and our income level. Those are the 2 lighter graphs. Now, a country that is doing very well, the top of the pops is Denmark, and seems to keep its place there all the time. Denmark has a spider graph that looks like this.
Okay.
Drop it in again. So Zimbabwe, at the other end of the scale, has a graph like this.
Yeah.
So what you see is even if you're thinking of going on holiday in a particular country that you haven't visited before, take a look at the spider graph on the rule of law index, and you will know how safe you're going to be, and whether you're going to get home again, and whether if something goes wrong when you're there, you will be well treated or not. Because the bigger the graph, the more intact the rule of law. The smaller the spider web, the less intact the rule of law. So we come in somewhere in the 50s. We don't do so well on corruption. We do very well on human rights. And as you can see, our graph is different scores for different aspects of those 9 factors that are put into it. So the sadness with South Africa is that we've recently been grey listed, which is an indication that the Financial Action Task Force does not believe that we are intact in our enforcement of the law against corruption, money laundering, and terrorist financing. And that feature is going to push us down in the 2023 index when it gets published. But as matters stand, the 2022 index is out, and South Africa is a sort of middle-ranking country on most schools.
Okay, so this brings me to the question of, given that the rule of law is a foundational value of our republic, and it's enshrined in Section 1 of the Constitution as a value that our country is founded on, in your experience, your extensive 26 years experience at the Cape Bar, what has the rule of law's impact been on actions by government? So all three branches of government, the legislature, the state, and the judiciary, what impact has the rule of law had on their actions? What's the top thing that pops into your mind?
Yes, now I think that the fact that the Bill of Rights is justiciable it means that you can take people to court if you feel that your rights are being infringed. That is one of the fundamental differences that has come about because of the introduction of the current constitutional dispensation and the move away from the authoritarian parliamentary sovereignty of old. So if I can give you a quick, for example, that's got nothing to do with religion, but it is the case that got me interested enough to leave the bar and work in the NGO sector instead. I got a phone call one day from an old school friend who was an active editor of a small newspaper in Fish Hoek. And he said to me, what will happen if I set the railway carriages in the siding at Fish Hoek Station alight? And I said to him, Joe, you'll be sent to jail for arson. What is your problem? No, he said, we just can't get any answers out of Metro Rail after one of the youngsters in our valley, a popular young man, was murdered on his way home on the train. What had happened was that he went to assist a friend of his who had a little rucksack on his back and was being robbed. And in the process of intervening, he was stabbed in the neck and died. And Metro Rail were taking the attitude, we've got insurance, please don't ask us. The police were taking the attitude, safety on the trains is a Metro Rail problem. Metro Rail was saying, no, it's a law enforcement problem. It's not for us to do anything about it. Now, I looked at the Bill of Rights and I saw that everybody is entitled to their bodily and psychological integrity. Everybody is entitled to life and to freedom from the violence that had overtaken this young man's life. So we started a case about the matter, which after 5 days in the High Court, 1 day in the Supreme Court of Appeal, and 2 days in the Constitutional Court, ended with a finding by the Constitutional Court that Metro Rail is obliged to take reasonable measures to ensure the safety of people on trains. Now, that case could never have been brought in the old South Africa because rights under the Bill of Rights, there was no Bill of Rights. So rights of the kind that are protected by the Bill of Rights could never be enforced by going to law. And as a result of that case, big changes occurred. I don't think the trains are as safe as they should be, but a great deal more security personnel were put in place, and many cases, a whole cottage industry of damages cases for people who have been injured because they have been attacked or pushed out or otherwise damaged because of the way that the trains are run. That has given people recourse that did not exist in the old South Africa. If you fell out of the train in the old South Africa, that was that. If you get pushed out of the train in the new South Africa, you have a cause of action because they are using the train with the doors open.
So, Paul, that's very interesting because you effectively answered a question that we hadn't asked, but we were about to, which is why is the rule of law central to the enjoyment of rights in the Bill of Rights? And I think you've given some excellent insights and obviously a wonderful example of that. But perhaps to be more specific and to bring it home, is the rule of law of specific value to bring us the ability to enjoy our right to religious freedom of religion, thought, belief, and opinion, as is obviously specifically enshrined in Section 15 of the Constitution? And how do you think, just in your view, the rule of law has actually been helpful in upholding that critical right?
Yes, certainly the fact that religious freedom is a justiciable right under the Bill of Rights and the constitutional dispensation as we know it in South Africa today means that freedom of religion is far better protected than it ever was in the past. You may be interested to know that freedom of religion is regarded as factor 4.5 on the index of the World Justice Project, and comparisons are drawn between different regions in the world. Not surprisingly, North America and Europe come up with a score around about 80%, but Sub-Saharan Africa does quite well. We come in third place in the regions of the world. And of course, the Middle East, where there is a great religious intolerance and even efforts to destroy the state of Israel, comes in bottom on that particular score. So it may be of interest to your viewers to put up that graph of the status of religious freedom, factor 4.5 on the rule of law index scores, just to show how well South Africa and Sub-Saharan Africa does on that front. I do believe that the right to religious freedom makes a country more or less civilized across the entire globe. It's a very good litmus test of how much freedom there is in any given country, if that country scores well on the freedom of religion index.
That's very interesting. You know, I think the fact that the constitution of this country gives that specific protection, and as you've pointed out, the rule of law effectively upholds that and makes that judiciable, is significant, and I think of a great benefit to South Africa. I mean, that's obviously what we 4SA do. We exist to uphold and protect and promote the right to religious freedom specifically, and obviously it's got a lot of related rights that are attached to that. But in the country I come from, the UK, when I was at law school, I asked my professors, what is there in this country that actually protects these freedoms? And the answer was basically tradition. You know, the Magna Carta, the fact that we're a Christian nation, what have you. And yet here we are literally 40 years later, the very place where I studied law at the University of Bristol, a street preacher is arrested for a public order offense, which they said was arguably hate speech, simply for quoting a verse of scripture. You know, we have people who've just been arrested praying silently within the vicinity of abortion clinic. This is also some public order offense. And so we can see that there is actually no constitutional right in the UK that one can apply to and say that this is why I should be protected and promoted. So I just like your view on maybe the advantage that South Africa therefore has from a constitutional and legal point of view in actually being able to protect this fundamental freedom.
Well, as an English-trained lawyer, you will know that the rule of law really does stem from the Magna Carta, where the feudal lords had enough of the king lording it over them, and really diluted the divine right of kings sufficiently for the rule of law to commence. Today in London, there's a place called the Bingham Institute for the Rule of Law, where a lot of learning goes on in relation to the applicability of the rule of law in various countries. Your examples bring to mind people in South Africa complaining about the call to prayer at Muslim mosques in areas which are populated by a variety of people who do not feel the need to be called to prayer at 5 o'clock in the morning. And then it becomes a nuisance issue and a balancing act between the devotion of those who are called to prayer and the right to peaceful sleep or psychological integrity of those who prefer not to be called to prayer at the crack of dawn. And in a civilized society, a via media is usually worked out, but sometimes, even in South Africa, there are instances where exercise of religious freedom has to be done in a way that does not impact negatively on the rights of others. So always a balancing act and a question of whether on the facts of any particular case, it can be said that there has been a threat to or infringement of the right to expression of religious freedom.
So Paul, I'm so glad that you mentioned that. So this isn't a question that we prepped, but seeing as we have a bit of time left, I'm going to throw it in the mix. Because our Constitutional Court has said that, you know, religious freedom, like Michael said, is closely related to other rights. It's closely related to the right to dignity, because if you don't have religious freedom, that directly impacts on your human dignity. Your right to equality, your right to freedom of expression, all of these are, Concord has said, a web of mutually supporting rights, to borrow on your spider graph there. So when different people with different, and our right to religious freedom, as Michael hinted at, is more than just, it protects more than just religion. So Section 15 in our Constitution, which entrenches the right to religious freedom and makes it justiciable, also protects your right to freedom of conscience, thought, belief, and opinion on top of religion. So it's very, very wide, and we can see how that is very centered to who we are as people. Because if you don't have freedom of thought or freedom of conscience, then really you are not going to be able to be granted. You're not living a dignified life in society. So obviously, when you have different people with different worldviews, different opinions, different thoughts, beliefs, interacting in the public realm, those rights are going to come into contact with one another. We're going to see, you know, the right to freedom of expression affecting others. We're going to see freedom of association, all of that happening. The balancing act that you hinted at, in your mind, how does that work? Because we should have a situation where everyone in our pluralistic and diverse society is granted the opportunity to live according to their conscience and so forth in the public realm, and where we don't see religion and expression of that, because obviously religious freedom is more than just your internally believing in your heart as you choose to believe. It's also being able to express that externally through manifestation and teaching and worship and all of that. How do you see that balancing act happening? Because it's easy to say like, oh, okay, you know, we see religious freedom up here against the right to equality, but people forget that religion and belief are also themselves, and conscience are equality rights and grounds in terms of Section 9 of the Constitution. How do you see that balancing act happening in a pluralistic, diverse society as ours?
Yes, I think it comes back to the old golden rule, do as you would be done by, which in the context of our Bill of Rights is the primacy which is afforded to inherent human dignity. You cannot be enjoying inherent human dignity if a Jehovah's Witness knocks on your door every hour on the hour, 24 hours around the clock, in order to sell the watchtower to you. That would be an infringement of your right to dignity, to your psychological integrity, to your enjoyment of your property rights and all manner of aspects. So remember, all of the rights in the Bill of Rights are subject to limitation, provided the limitation is of a kind which is of general application in an open and democratic society. And that is how you get to rulings in a court of law. Inherent dignity right at the front of the stove, enjoyment of the rights and freedoms, and the promotion of equality are the three aspects of the Bill of Rights that are brought out in Chapter 1 of the Constitution as being foundational to our new order, the Bill of Rights being Chapter 2. And of course, we all know that under Chapter 2, the state is obliged to respect, protect, promote, and fulfill all of the rights guaranteed to everybody in the Bill of Rights, and that would obviously include the Section 15 religious and conscious and thought rights that are entrenched there.
All right. Thank you so much for such an insightful interview, Advocate Hoffman. It was a real pleasure having you on. It has been really informative for us, and we hope for our viewers as well.
Good day. This is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.